Labor relations legislation in the construction industry is a very complex topic, and it involves many different stakeholders who don't always see eye to eye. Before I get into details of the report, let me take, that's an understatement, let me take a step back to give you a bit of a context for today's announcement. As we all know, the construction industry in Alberta forms a significant part of our economy. Alberta's construction sector employed approximately 231,000 people, or if you wish, over 10% of our workforce in the province, and accounted for roughly 35 billion, with a B, billion, in expenditures just in 2013 alone. Over the last few years, the industry has changed significantly. Many massive oil sands projects are underway, each spanning many years and demanding thousands of workers into the future. There has been a strong drive for modularization in the industry, and we have all heard about that, with pre-built or partially pre-assembled components replacing on-site construction using Canadian workers. With huge projects, obviously, come huge costs, and there has been a significant drive to improve efficiency and productivity in Alberta. Alberta construction industry has many multinational firms spending billions of dollars annually. Some of these firms prefer to use unionized contractors, and some don't, and many play in both worlds. In the industry, commercial and institutional construction sectors employ approximately 46% of unionized workforce. As far as workers are concerned, there are traditional building trade unions in Alberta, as well as what we call often alternative unions, such as the Christian Labour Association of Canada, and obviously non-unionized workforce too. Unionized workers represent 15% of the workforce in construction, compared to approximately 20% of the overall workforce. These unionization is at 20% in the overall workforce. So unionization in the construction industry is somewhat lower. These groups and their contract partners are highly competitive, and they all encourage government to modify legislation now and have for many years in the past. Andy was asked to do a complete review of Alberta's labor relations system and make any recommendations he felt were needed. His report is thorough, well-researched, and in my mind, completely unbiased. It recommends 6 small but very important changes that are designed to strengthen the industry as a whole. What's important here is that no particular group or particular stakeholder is favored by these recommendations. Rather, they are intended to maintain the important balance between the needs of industry and those in our labor industry. I should also let you know that prior to this review, because some of you may know that this report has been, shall I say, dogging me for a number of years, no matter what ministry I was in, I have also retained the services of 2 local lawyers that do a lot of work in labor law, Mr. Dwayne Choman and Mr. John Hope, who have also reviewed this file and provided me with their legal advice, which thankfully, in my case, fully aligns with the recommendations of Mr. Sims, and those 2 lawyers have also extensively consulted with all stakeholders on this file. I can tell you with all confidence that over the last number of years, all MLAs of all political affiliations have been quite heavily lobbied by all players within the industry on this matter and have been encouraged to put this matter to rest. It is very important that we deal with this particular issue, and maybe Mr. Sims can comment on it a little later, in view of the fact that some major labor negotiations will start this fall in commercial construction industry, and having any unanswered questions hanging while negotiations take place would simply not be healthy to our economic development and to the outcome of those negotiations. Alberta has been enjoying labor stability in the construction industry beyond any other jurisdiction. We have had a labor code that was very responsive to the needs of the industry. It needed some updates. All parties have been lobbying for different changes in the code. What we have here is a balanced set of recommendations. And let me briefly walk you through it. And then, if I may, to be able to rely on the expertise of Mr. Sims, he will elaborate further what those recommendations mean and why. So number one recommendation is to require all collective agreements to include provisions for major projects agreements. When projects are designed as major, disputes regarding the terms of a collaborative agreement are resolved through binding arbitration rather than strikes or lockouts. Second, confirm that all employee multi-trade bargaining units can be appropriate in certain cases. This allows employees to choose a single trade union or a multi-trade union. 3, protect local unions by requiring international or parent unions to adhere to hourly rates and other terms of existing collective agreements. This means that once an agreement has been made, the terms in place can't be avoided or undercut by other national unions. 4, direct Alberta Labor Relations Board to consider the anticipated size of a bargaining unit when it's issuing a union certification. This is because the size of a group can change considerably between the time when it first applies for certification and when it's actually in place. 5, direct the Labor Relations Board to examine whether major electrical transmission lines should be considered as special construction for the purpose of bargaining. Currently, these projects are considered general construction, but they have a lot in common with other special projects, including having work that is not specific to one particular trade. 6, finally, Andy has recommended that government institute periodic stakeholder roundtables discussions to facilitate dialogue and understanding within the construction community. I will now turn this over to Andy, and he will walk us through more detail on those recommendations.
Thank you, Minister. Thank you both for the opportunity to speak today and for your both confidence in asking me to carry out this task and the assistance of you and your officials as I did so. I want to begin firstly by talking a little about the scope of the review and the process. This review is only in relation to construction legislation and not in relation to employment relations generally. Both are included in the Labor Relations Code, but they are quite different worlds. They are different employers and, for the most part, different trade unions. As to a process, there was an initial review, as you indicated, that was much more informal to government. I undertook this review and had informal discussions with both the people who conducted that review and with those who spoke to them and reviewed the submissions. I then decided to proceed with a series of discussion papers, and those of you who have the report will find at the back 4 discussion papers that focus specifically on topics that affect the construction industry. And I sought and received very detailed and very helpful submissions on the topics raised in each of those 4 papers, and you'll see at the very back a list of the submissions that were received. I also met with industry, and there are in the construction industry 3 main players rather than labor relations generally. General labor relations, you have employers and management. In the construction industry, you have owners, employers, and management, and that's a very important distinction. Received their input formally and informally and attempted to digest it. If I could stand back and distinguish the construction industry in a couple of ways that doesn't apply to other industries. The first distinction is that construction workers are needed when they're needed and not needed when they're not needed. And we have gone in Alberta through periods of oversupply and undersupply as we have experienced booms and busts over the years. I've been involved in construction labor relations for almost 40 years now, and I've seen both. But a feature of the average construction employee's life is that they have periods of high employment at lucrative rates and very long hours, and periods when they are underemployed. At the moment, we're in a period of acute labor shortage, particularly in some trades. It was an industry that was dominated by what we call craft unions, electricians representing electricians, carpenters representing carpenters. That has changed, not completely, but has changed in a couple of ways. Firstly, not all employers design their work practices to fit with those craft jurisdictions. Secondly, the unions have emerged, particularly in the commercial and institutional sector, but increasingly in the industrial sector, that contract with trade unions that don't work on a craft basis, but on an industrial basis. And there have been changes in technology. The situation we have right now, it appears to me, and I refer to this throughout the report, is that we have a demand for construction labor, firstly, that is short and will remain in short supply for a while, and that will demand those who choose to work through building trade unions, the craft unions, that choose to work through industrial unions, Unifor or the CLAC, and those who choose to work non-union. One of the biggest sources of consumption is the development of our huge petrochemical projects, particularly in the Wood Buffalo area, but also in the Cold Lake area, which consume a massive number of construction employees, increasingly in maintenance as well as in construction. One of the challenges is to ensure that those various forms of union representation or non-representation can all work together in one of these plants. Ever since 1972, we have, in Alberta, created what we've called carve-out agreements, which are special agreements to ensure that these projects can go ahead for their duration without strike or lockout. That's relatively easy. I won't say easy, but it's relatively easy when all the unions are affiliated with one another. But when you have unions that are competing with each other and competing with people who work on the merit shop principle, non-union, that becomes to be a bit more of a challenge. One of the things I've recommended is that we restructure the provisions for what's called Division 8 to continue the strike and lockout regime for major projects. And that would be achieved either voluntarily by long-term agreements entered into by unions and management, or on a mandatory basis through a government designation order that would provide for government sanctioned terms and conditions necessary that would apply to everybody in order to have a harmonized working relationship on a project. So one of the recommendations is to rewrite Division 8 to say that under every construction collective agreement in Alberta, they must include those harmonization terms if they are to work on that project, and they must include no strike, no lockout provisions for the duration of that project, even if there is a strike or lockout going on somewhere else. The next point I want to make, and it really goes beyond the petrochemical projects, is that we chose in the 70s and have continued until now a system that not only has collective bargaining for employees, but has collective bargaining for employers. Employers have chosen in most major trades to select a registered employers organization, which, if you like, is a trade union for employers. That so far has only applied to those who bargain with the building trade unions and not to those who bargain with industrial unions or for all employee units. A very important question that has come up in this review, and it is something that I had to ask seriously whether its time has passed, is registration still healthy? My conclusion is that it is. It has achieved, particularly since 1988 when it was resolved, a completely strike and lockout free period in that industry. That is unrivaled in terms of jurisdictions across Canada. The CLRA as employer representative, including the Electrical Contractors Association, the Mechanical Contractors Association, and so on, they have been able to bargain, sometimes tensely, sometimes comfortably, with the building trade unions. To adopt a totally competitive system would dismantle that. Because under that system, every employer is bound by the same collective agreement. I think registration should continue because of its track record, because it still works and still commands a great deal of support. I think it should continue because it also provides investors with a great deal of certainty. There are, however, many contractors who operate in partnership with unions who are not caught by registration, who are not part of the building trades, and they do not, therefore, have to follow the one collective agreement, but can underbid each other. They have done so successfully so far, but they are not bound by the same no strike, no lockout provisions or limited strike and lockout opportunities that apply to registration. To dismantle registration would mean each employer and each trade union would compete not only for business, but in the labor relations arena. While there are some who favor that, I think that's an area where the market should prevail. That sector has taken over about half the industry and has done so notwithstanding our current legislation. And so I am resistant to see or to recommend that registration be dismantled because of it. When you have a registration system that binds many employers to the same agreement, one needs rules to prevent undercutting of that so that people who play by the rules are not undercut by people who avoid the rules. And I have made one recommendation in terms of the scope of registration to make sure that when a local trade union is bound and can only collect and must abide by a collective agreement, it cannot get round that by contracting through an alter ego local of the trade union or its international. Employee choice is the hallmark of the Labor Relations Code. Certification, the right for a group of employees to be represented by a union, to choose that or to revoke that choice, depends upon a vote within a constituency we call a bargaining unit. The question is, what should the constituency be? Should it be all employees of the employer, or should it be all electricians of the employer, or plumbers of the employer, craft by craft? We have two models operating right now in Alberta, and they are inconsistent on this point. And my ability to bring consensus on the point is obviously limited because of that, because there are just two different worlds. I have recommended that the Labor Relations Board no longer follow a policy of only certifying on the basis of a craft unit, but that it be employee choice as to whether it be an all-employee unit, if that's the way the employer has structured itself and the way the employees choose, or a craft-by-craft unit, if that's the way the employees choose. And I've suggested there be a vote system so that employees can switch from one to the other if need be. I think the one other thing I wanted to mention, if I could, Minister, and that was the provision for communications. And a Minister of Labour, however configured, I think would be well advised to recognize that in Alberta there are some very important stakeholder groups, owners, trade unions of several different types, and employers organizations of several different types. It is no longer sufficient to say, well, they'll work things out at the bargaining table, as if it was just one group of managers and one group of employees. There are now a variety of interests. Because of the volume of our construction and our development and our success, there are competing interests based on huge economic opportunities and an economic pie that is being divided up. There are major ideological differences. I think it's healthy that these people all sit down, maybe once a year, and speak with the minister face to face and all together, rather than simply relying on each one's lobbying and treating labor relations as a political process when it is, to my mind, a very important part of our economic stability. I'm sorry I've talked too long. I have tried to summarize what is a 162-page report into something digestible. I don't think I've achieved that, but I'm certainly happy to take any questions.
Thank you. I appreciate it. Well, suffice it to say, Mr. Sims obviously has a good grasp of these matters at hand, and we have done our utmost to make sure that we address these issues from one vantage point. And the vantage is what is good for Alberta, what is right for Alberta, and what will advance our economic growth in Alberta without looking at what Mr. Sims referred to as some of the ideological differences or simply competitive differences that these parties have from time to time with each other. We have very carefully reviewed the argument of competitiveness because it has been presented to us that through changes to a labor relation code, this province could be more competitive. I think all Albertans know that we are not losing contracts to other provinces, and frankly, our only limitation to do more work in this province is shortage of labor. So there are no competitive disadvantages stemming from the code. And the government has considered the recommendations and has decided to accept the report as it is written, release it today publicly, and it is available to all on www.work.alberta.ca. And most importantly, proceed with these recommendations and these recommendations only as any potential legislative or other changes to the labor relations code as soon as possible. So our message to Albertans is that we have done a thorough, probably one of the most thorough reviews that I have ever participated in, as this has been part of my life for quite a while. We are confident that this will resolve any and all issues that have been brought forward to us, perhaps not to everyone's satisfaction on every recommendation, but as Mr. Sims has indicated, the world of labor is always polarized, and in a perfect world, you have either both parties equally happy or equally unhappy, but it is not favoring from any perspective one side or another, and that we will maintain what has been proven is the balance of our current legislation, the labor code. Our labor code is considered to be very effective because, and the proof is in the pudding. We don't have strikes, we don't have lockouts, and our economy and our workers and our owners are firing on all cylinders. And the only thing that is slowing them down is the fact that they don't have enough workers to do more work. So at this point, I will rest my comments, and we will open ourselves up to your questions.
What does as soon as possible mean for the legislation? Does that mean the spring sitting? I mean, have you got it ready to go, or are you talking about the fall or next spring? Or?
You know what? I have to still put this through the process. It has gone through agenda and priorities. It has gone through a cabinet and caucus. But this is, this is a hefty report. The labor code is one of the most complex pieces of legislation probably that we have on the books right now. If I can do this this spring, I definitely would. But at this point in time, I cannot commit myself to it. I can tell you as soon as possible.
Why did it take you so long?
I was looking at your smile. When you smile like that, it's never a good question. You know, this is a file that stayed with me no matter what ministry I was in. I don't know if you realize that, and I guess a series of premiers have decided that if there are some of those issues that that at the end of the day will require making some difficult decisions, give them to Lukasik, and this is one of the last ones that has been on my desk. This report I have given more thought and consideration than anything that I have worked on prior to, because I know what adverse effects could occur if you don't make the right decision. This is the labor code in particular that deals with construction industry, deals with, as I said earlier, with $35 billion a year of construction in this province, and it employs, or is part of the employment of a large number of high-earning Albertans. There is no room for error over here. And yet we had three rather polarized groups that were asking me and the government to make a decision, and each one of those asks was actually mutually exclusive. They have a very different view of what the world should look like in labor relations and in the construction industry. And all have arguments that are logical, but not all of them look at construction industry and our economic growth from the perspective of what is best for Alberta and for Canada. My job was to wade through all that and answer the question, if I was to go your way, would this be ultimately the right thing for Alberta? And since oil sands, employ more people in Ontario than their auto manufacturing industry, is this good for the entire country? And that is why I went to the length of first asking Hope and Choman to tear this apart, tear those three arguments apart, and give me background information on whether indeed this is just an ideological battle between long-time opponents who will continue to battle into the future, no matter what decisions we make, or are there really meritorious arguments, and could we be more competitive? Could we do more work in Alberta, or better, faster, more collaboratively between different employers and different labor organizations if we were to make any of those changes that they recommended? And the answer from the initial, rather cursory, but nonetheless through consultation review was that, majority of the arguments are ideological. They simply see the world through a prism where the other parties are either competitors or are not well ideologically aligned with their view. But there are some changes that could actually be made that will allow for better collaboration on these large projects where we have all three working side by side and you wouldn't know who's whom on a job site, and working really well. We can make it smoother. So that is the reason why I have retained the services of Mr. Sims. And that in itself was a difficult decision, because you can ask the Alberta Law Society to give you a roster of all labor lawyers, and you run them by those three, and everyone, someone will have objections to, because there is this perception that this world, again, is polarized pro-labor, pro-employer, and in this case, pro-owner of this kind or pro-owner of another kind. Mr. Sims, without a shadow of a doubt, was a lawyer that all players in the industry respect, and they have worked with Mr. Sims through consultation for over a year. All parties have been asking me to deal with this as soon as possible for a couple of reasons. Number one, from an employer's perspective, any question marks hanging over labor code can have adverse effect on investment into their projects. Nobody wants to invest into a world when you don't know whether there's going to be labor stability and labor supply. From both unions and employers' perspective, it was very important to them to get this done before the end of this summer, because there are negotiations coming up. This is as soon as we could finish Mr. Sims' review. I have just received this report several weeks ago, months, 3 months maybe ago or so, and this is the earliest that I could convert this into a document that I can present to you. So it took a while, took a long time. I'll be the first one to share you. And if you speak with MLAs current and of the past, they are all very familiar with this. As confusing and technical as the subject matter is, you will be hard-pressed to find an MLA who doesn't understand it well, because this has been their life for a number of years. Every party that in any way is a stakeholder on this file has made sure that their elected officials of all political affiliations truly understand this issue from their perspective. So consultation has been robust.